Hi, everyone. This is Amy, the attorney. We are live today with Stephanie Burton, who is a criminal defense attorney practicing in the greater Kansas City area. We are specifically talking to Stephanie today about criminal courts in the era of COVID-19, more specifically Jackson County, where Stephanie has a lot of her cases. She has been a practicing attorney for quite some time, and she previously has worked in the Wyandotte County prosecutor's office in a special division. She was private attorney, prosecutors, now is back being a private attorney. She handles all sorts of cases in the criminal courts, all the way from a traffic ticket to murder cases. So she knows what she's talking about. We are going to talk first about the Jackson County Jail and the situation there. We're going to talk about what hearings and what trials are happening in Jackson County Circuit Court. We're going to talk about Jackson County Circuit Court, exactly what kind of court it is. And then finally, we're going to wrap up and talk about a trial and sort of the life of a case, a criminal case, what exactly happens. So Stephanie, I am so glad you are here joining us. Thank you so much.
Thank you for having me here, Amy. I'm excited to be here.
It's exciting. It is exciting. So the first thing we're going to talk about is we are going to talk about, let me get here we go. We are going to talk about, the Jackson County Jail. And just to bring people up to speed, there has been a lot of focus on the Jackson County Jail in recent years and the conditions in the Jackson County Jail. We've made the headlines of New York Times for some of the processes in women being able to wear underwire bras into Jackson County Jail. We have definitely made headlines, not necessarily in the way that we want. So the first thing I'm going to ask you, Stephanie, is what is the situation now in Jackson County, at the Jackson County Jail?
So Jackson County still has a number of issues. They have been working to fix some of those issues, but they still have a very long way to go. So we have issues now where we've had reports that there have been at least 3 inmates that have tested positive for COVID-19 and at least 1 employee that has tested positive. Now, the biggest concern with that is, we had public health issues and security issues at the jail prior to COVID-19. And now all of this has been exacerbated by the COVID-19 crisis, where we have people who are already in, I don't want to use the word horrible, but less than favorable conditions. And then now we add a global pandemic on top of that to these conditions. And so I think the courts have done a great job of being sensitive to that issue. Presiding Judge Byrne, he did issue an order that said that if the bond amount is $5,000 or lower, then it's an automatic RR. It's an automatic signature bond on those cases. And so those people can be released without having to pay a monetary bail. And then you also have where I just saw a report from earlier that over 200 inmates have been released since the pandemic. And so I know the prosecutor's office was making some efforts to get people who are nonviolent offenders that are in custody out of custody. So to reduce that crowding and to get some people out. So I know there have been some strides on the part of the court and on the part of the prosecutor's office to get some of these people out. We have issues where we have some people who are of a higher, of a higher risk,
yeah.
Where they are trying to get out, where we as their lawyers are filing motions that our clients have asthma, bronchitis, respiratory issues, they're elderly. And we're trying to get those people out as well, but we always have to remember that the court has the duty to balance not only the public health of the people that are inside the Jackson County Jail, but also the public safety of those who are in the community. So it's a delicate balance, but I think Judge Byrne has been doing an excellent job of trying to reduce those numbers and trying to keep people at risk, not at risk, but trying to reduce the risk of those people in the jail.
Great, great. Tell me about clients, your client visits in the Jackson County Jail right now, or lack thereof, what it has been and what it is currently. And maybe you could even talk to what would be the ideal situation for you to be able to speak to your client, considering all the circumstances.
So for me, the utmost importance when I'm seeing my client is protecting my client's attorney-client privilege. And so the way they have visits set up, if you go to the jail and you want to see your client, they're going to take your temperature and then they're going to let you speak to your client in the non-contact room. That's a problem for me because you're speaking on a phone and you're speaking through your client over the phone. And those always have the potential of being recorded. And not to say anything bad about the Jackson County Jail, but I don't trust anyone with my attorney-client privilege. That's a privilege that only my client can waive. And so I'm not going to be willing to go to the jail and speak to my client over a phone. I'm not going to talk to my clients about sensitive information on the phone. So it has really put our visits at risk because we know that institutions, prisons, jails, they're a hotbed for infection. And it's not just, when one person gets it, they're piling people on top of each other, but that's a whole nother Oprah for me. But they're already overcrowded. And then we have these situations where we have sanitation issues, and on their best day, we've got sanitation issues. And then we're putting a lot of people, not just the people that are inmates there, but the staff, the attorneys coming in there, social workers, probation and parole, everybody that has to come and see these people is all at risk. And we don't know the measures that they're taking to sanitize, because I know they can't use anything that's going to be lethal. So you can't just use straight undiluted bleach to clean, because they have to protect the risk of inmates who might be suicidal or things of that nature. So it really puts a damper on me being able to see my clients. I have a few clients and I'm not going down there. I'm not going down there to see them. I'm not going to settle for a non-contact visit. And I'm not going to put myself or my client at risk by going down there.
Do you know if family members are allowed to visit at the Jackson County Jail?
I don't know. Before COVID came about, they were doing video chats. So they weren't taking them up to the respective floors and talking on the phones like they're trying to do with us. They had moved to a video platform. So they may still be doing that, but I'm not sure.
Okay. So, but it would still require them to go to the place itself, go to the location itself.
I believe so. Now, there are some jails that do video where you can do it from home, where you can do it from your computer. I would hope that would be an option, but I just don't have the answer to that.
Okay. All right. We're going to move on to the second topic. We're going to talk about the Jackson County Circuit Court itself. We're going to talk a little bit later about what kind of court Jackson County is. But for now, in terms of criminal cases in Jackson County, what is the situation now in terms of getting your case heard? If you're a defendant, just kind of give me the lay of the land for criminal defendants and criminal defense attorneys in Jackson County.
So everything that's occurring right now is very different than what we're used to. So usually our courts move on a timeline for speedy trial reasons, constitutional protections, and there are benchmarks in place that the Missouri Supreme Court has put in place of how long these cases should be on the docket. And that's why when you look at the docket, it'll say age of the case, so they can know where we are as far as those benchmarks and how, if we need to get this case going. So as far as the people who are having hearings, if you're in custody right now, and you're newly arrested, God forbid, let's just say you're newly arrested, and you've got to be in front of a judge to take up a bond issue. And so with that, they have the people who are in custody appearing by video. And that's not anything new to Jackson County. They've had video hearings for quite some time, but they are now to the point of where the Judge Burnett in Criminal A is having to see a lot more people by video, because it used to be like more of like a pop docket that you would have on video, but now she's doing the dockets for the people who need to be seen that are in custody by video.
Okay, very good. And those, and so if you, are people that are in the jail, or in general, could you be seen by video?
Those are the people that are in the jail. If you are not in custody right now, your case is being continued out a ways. So Judge Willingham started doing that early on, because remember, the court started making modifications before the city started making modifications.
Right.
And so if they're not in custody, the court has been sending them notices continuing their cases about 60 days out.
And if you're represented by an attorney, would you get that information from your attorney if your court date has been canceled or continued, or would you be able to look online? Where do they look for that information?
They can look on CaseNet, on Missouri CaseNet. If you Google Missouri CaseNet, you can click right on it. It'll say your Missouri courts. You can look up that information there. And then they notify the attorneys, but they're also sending the letters to the defendants at their last known address.
Oh, good. So if you have the correct address and the charging documents, you'll be notified by mail. That's
correct. And so that way the pro se litigants, the ones who haven't hired attorneys yet in criminal cases, they're still getting the information.
Great. All right, let's talk about jury trials in Jackson County. Are those happening right now? And what's the status of a jury trial in Jackson County?
So per Judge Burns' administrative order, all of the trials from March, April, and May have all been canceled. So they're going to be moved to a later date. The ones that have not been under the administrative order, so far June has not been canceled yet. Judge Burns did allude to that in his town hall, that it was a possibility that June jury trials would also be canceled. And so I've got jury trials that are set in August. I'm afraid those may not go, because all of the ones that had to be canceled prior to that are going to need to be tried. And so presumably those are older cases, and they're going to trump my cases that aren't very old, and they're probably going to punt us down the road.
Okay, let's break that down a little bit. So if there's a hierarchy of when a trial is going to happen in Jackson County, and I don't know if it's written or if it's just the protocol around there, but the hierarchy would include people that are in custody are going to get to go to trial before people that are not in custody.
That's correct.
Okay. And older cases also move up on that list of the hierarchy of when cases are going to go to trial.
Correct.
Okay. So if you've got a newish case and you're not in custody, it's likely that your trial is going to be pushed back quite a bit.
That's correct. I mean, and it's almost a definite that your case is going to get pushed back.
Okay. Okay. So the next thing we want to talk about is, I want to talk specifically about what kind of court is Jackson County. And a lot of my practice is at the municipal court level, which are misdemeanors and ordinances, but in Jackson County Circuit Court, in the criminal division, in the criminal section, what kind of cases are we talking about?
We're talking about your felonies and your misdemeanors in state court. So Jackson County is a state court, circuit court. So that means that it's the state of Missouri versus John Doe, state of Missouri versus whoever. So these are your felonies and your misdemeanors. These aren't your city ordinance violations. I mean, there's a municipal division of Jackson County, but primarily if you are in criminal court, you have been charged with a felony or a misdemeanor.
And the felonies and misdemeanors generally mean that the punishment could be time in prison.
That's correct. So if you've got a misdemeanor, you're looking at up to a year in the Jackson County jail. And then if you've got a felony, then you're looking up, just depending on what kind of felony that you're looking at, you could be looking up to life in prison. Okay.
All right. So just, it goes along the whole gamut of the kind of cases that that could be going. All right. I want to talk to you a little bit about judges and something that the way it's set up in Jackson County Circuit Court, how somebody becomes a judge in Jackson County Circuit Court, and also what happens. I want to talk to you about retention and the retention vote. So why don't you talk about how do you become a judge in Jackson County Circuit Court?
So we, in Jackson County, we have the nonpartisan court plan. So what happens is you make application to be a judge, and then that application is reviewed by a panel. And then that panel will then interview you, and then they send a list of 3 names up to the governor. And then the governor's staff will interview you, and then they'll make recommendations to the governor. And then the governor has a certain amount of time to appoint a person to that seat.
Okay,
so,
go ahead.
Oh, so it's not like, in some counties you have elections where the judge is, runs a political campaign to become judge. But we have a merit-based system in Jackson County, which I prefer.
And so once a judge is appointed in Jackson County, are they then a judge for life?
No. So we have a retention process where they are on the ballot on whether or not the community feels that they should be retained as a judge. So if the governor appoints somebody and the community believes that they're a terrible judge, they shouldn't be here, this is a mistake, they can be voted out. They can be voted out of that seat. And so our judges are still accountable to the citizens of Jackson County.
Okay, very good. And they happen every 5 years, the
Yes.
retention vote? Okay.
Yes.
So all of them can be held accountable and are held accountable. Although I will say, I don't believe that many have been kicked out due to the vote. I don't know what the number is, but it's pretty low.
During my time that I've been practicing, I haven't seen anyone kicked out during the
vote. Yeah. So they more than likely not. They're at the end of the ballot. Generally, the judge elections are at the end of the ballot, the retention vote. It's a yes or no vote. Every time it's somebody different on the ballot. And from my work on elections, many people don't even fill it out. It's very low since it's so low on the ballot, people go and fill out for president or senator or governor and then kind of check out from there. So, but it is something obviously important. And if people did feel, and there was sort of a movement about it, that felt like there was a problem with the judge, there is a way for the community to mobilize and get that judge out.
That's correct.
Yeah. All right. So we're going to move on to our last topic. We are doing good on time. I'm proud of us. I want to talk to you about just basically the elements of a criminal trial. And I want you to kind of go through from start to finish, and I'll probably interject with some questions, but how exactly a criminal trial proceeds in Jackson County.
Okay. So in Jackson County, you start off with your charging document, which is your complaint, or if it's been sent to the grand jury, the indictment. And so from there, when you're charged with the case, then you go in front of a judge for what's called arraignment, and the judge will read you your charges and alleging what the state has charged you with. And so once they do that, there's a determination of bond. If the court has already issued a signature bond, then most likely you're not going to be in custody. But if you are in custody, that's the time where your lawyer will either set up a date for a bond hearing, or they can also take up bond that day, depending on what your charge is. There are certain charges that require victim notification, and they can't be heard the same day that you're brought in. And then after that, you have to determine if the case is going to get negotiated, which is what you call, a plea agreement, or whether or not you're going to go to a trial. And so if you're going to go to a trial division here in Jackson County, things work differently in Independence versus Kansas City. In Independence, there's usually an option to have what's called a preliminary hearing. And that's a hearing where the court determines if there's probable cause to move you to the next level, to move you to a trial division. And then in Jackson County and the Kansas City division, most of the time, you're not going to get a preliminary hearing. Most of the time, they're going to send it over to the grand jury, and they're going to indict you, and then they'll send you over to the trial division or to the settlement docket. So
okay.
at the go ahead.
Oh, no, go ahead. You go.
At the settlement docket, then your lawyer and the prosecutor are still trying to see if they can negotiate the case, or if it needs to, or if it's going to go ahead and go to trial. So once that determination is made, then it's shipped off to a trial division, to a circuit judge, and then it's shipped over across the street, as we always say, for lack of a better term, to the big courthouse across the street to get set for trial.
Okay. And I will say that the place where all those prelims and plea negotiations are happening is the Albert A. Reeder Courthouse. My uncle, named after my uncle, and I always enjoy seeing his name. Although I don't practice over there much, I do enjoy seeing his name on the courthouse. So yay, Albert. All right, so you get set across the street for trial. Are you still talking to the prosecutor about a plea?
Of course. I mean, the reality is that justice is kind of subjective. Sometimes justice is going to require an outright acquittal, hands down. But sometimes it requires softening the blow. I mean, we've got to be honest. And so if there's a situation where a case can be worked out prior to trial, then by all means, we should go that route. Trial is reserved for those cases where you simply can't reach an agreement, that it's one of those cases where you've got to go through it and make the state prove that you're guilty beyond a reasonable doubt. Sometimes you have to hold the prosecutor's feet to the fire if they just can't see what you're trying to demonstrate, and then let the jury decide.
Jury trials are notoriously risky. You go into it opening up the whole gamut of what could happen. Right. And so you, as a lawyer, a criminal defense lawyer, are managing a risk by pleading, by looking at the evidence, doing your due diligence on your part, advising your client. But in the end, whose decision is it to go to trial?
It is always the client's decision. It's the client's decision if they want to plead guilty. It's the client's decision if they want to have a jury trial. And your lawyer, we're kind of the navigator. We help you to know what your chances are, what the evidence is, what the strength of the case is, what the weaknesses of the case are, and help you to make your best decision by that way. And sometimes when you're looking at plea negotiations, you're looking at lowering that risk, because sometimes we have a situation where you're charged with something and it opens you up to a whole different range of punishment than you would be in a plea negotiation. Because a lot of times, and I mean, that's why they're called negotiations. It's a give and take. And so in exchange for not filing these extra 15 charges that you can file, we're going to go ahead and plead to this one charge and lessen the risk of and the range of punishment.
Definitely. Okay. So in a plea, is there ever a time where you won't know what your sentence, what your client is going to be pleading guilty to in terms of a sentence? Is there ever a situation where you're pleading where there's a bottom and a top or something like that, and you're letting the judge decide after the guilty plea?
Absolutely. So there are times where we have plea agreements where the prosecutor will agree to a lid of a certain amount. So let's just say we've got a murder case and we're going to plead to manslaughter, and they're going to offer a lid of 10, and I can or a floor of 2 and a lid of 10, or just a lid of 10, and I can argue for whatever I want. And so in doing that, these types of pleas, you really got to know your facts, you got to know your case, and you have to know your judge, because all judges are different. There are some judges I am extremely comfortable with open pleas on certain cases, and then there are some judges I wouldn't do an open plea on a traffic ticket.
Right.
It just depends.
Right. Do judges, oh my gosh, my question just went out of my head. Okay, so but more likely you have agreed to some sort of sentence. Is that right?
Correct. And that's the beauty of the plea, is that most of the time you know exactly what you're going to get as long as the judge follows the plea. There are situations where the judge doesn't have to accept it. The judge doesn't have to do what you all have agreed to. 99.9% of the time, the judges will, because the system only works if everybody keeps their end of the deal. So most of the time, especially our judges in Jackson County, they will respect the deal that has been negotiated between the lawyers because the lawyers know their case.
Right.
The only time I've had a judge that has been a little leery about it, they took us into chambers and said, hey, before I accept this plea, I want to ask some questions.
Okay. Do you have a choice of judge when your case gets shipped over to the trial division? Do you have a choice of that?
I wish, but no, they go on a rotation. Now, there is an option where if there is a judge that you just particularly don't do well with or you don't get along with, you can file a motion for change of judge, but you only get one. And so you have to weigh that very carefully, because if you file a motion for change of judge because you say, oh, I don't like this judge for this type of case, you could get a judge that's better that you like, or you could get a judge that's a lot worse.
Right, right. Okay, so say you've decided to go to trial and you're at trial. How many jurors are there in the trial?
So you get 12 jurors and usually 2 alternates.
And if all the 12 jurors are able to, what happens when they go up into the jury room? What exactly are they deciding?
So when they're deciding whether to convict, which means they have found you guilty, or they're deciding whether to acquit, which means that they have decided that the state hasn't put on enough evidence to prove you guilty beyond a reasonable doubt. So when they go up to negotiate in a criminal case, all 12 jurors have to agree unanimously that either you are guilty or you are not guilty. So it's not a majority like in civil cases. In criminal cases, everybody has to agree. And so if they can't agree, so once they're deliberating and they can't agree, then they'll say to the judge, well, we've been at this for a while and we can't reach an agreement, and the judge will usually send them back 3 or 4 times to negotiate some more. But if they can't, and they're what's called hopelessly deadlocked, that they just cannot agree, then the judge will declare a mistrial. So the jury's hung up, they can't decide, the judge will declare a mistrial and the case will have to be tried again.
Does a mistrial help or hurt your client?
Most of the time it helps, depending on, so after the jury comes out, after they're released from service, then usually the attorneys will have an opportunity to talk to them if they want to talk to you. Sometimes jurors don't ever like to talk to the defense attorneys, but they love to talk to the prosecutor. So they'll tell you, how many, who was the holdout, how many of you were voting to convict, how many of you were voting to acquit. And then based on those numbers, a lot of times we can get something worked out, because it puts the reality in for everybody of, our case isn't as strong as we thought it was on either side. Right. And so trials are exhausting. And if we can avoid having to retry it, then by all means we will. I haven't had any situations with the Jackson County Prosecutor's Office where after we've had a hung jury that they're not at least willing to have a discussion.
Okay. If someone is found guilty at a trial, who decides their sentence, their punishment?
So in Missouri, we do have jury sentencing available. And if that's usually on a case where the person has no priors, and you can allow the jury to assess punishment. And so when they do that, then the jury assesses a number for each count. And then you still have to go to an actual sentencing hearing in front of the judge at a later date.
And does the judge have to follow the recommendations of the jury?
The judge, and that gets kind of tricky too. So he takes the recommendations from the numbers, but he still gets to decide, like if you've got 3 counts, he still gets to decide if they're going to run together, which means that if you get 7, 7, and 7, that he's going to give you 1 7-year sentence to run all together, or he can decide to run them consecutively and do 21 years. So he still gets to make that decision as to how the sentences are run, but he doesn't get to go over that number for that specific count.
Okay, very good. And if it is not a first-time offender and it is something that is judge sentence, what exactly does that look like?
So when it's judge sentencing, then once the jury makes a determination on what's called the guilt phase, on whether you're guilty or innocent, then they just retire and they're done. And then it moves on to a sentencing date. And before you get to sentencing, the judge will order what's called a pre-sentence investigation report or a sentencing assessment report. And that is done by probation and parole. And they get all your family history, they get your work history, any kind of mental health history, and they make a recommendation based on certain risk factors of what the appropriate sentence should be. And then the state will argue what they believe the appropriate sentence should be, and the defense will argue what the appropriate sentence should be, and the judge will then make his decision, his or her decision, I'm sorry.
Yeah, I think we both, even though we're women in the profession, we have a tendency to say he when we're talking about judges. And it's not right, because there's probably more female judges in Jackson County than there are male judges, right?
Exactly.
It's sort of close, but all right. So is there anything that I haven't asked about criminal courts in Jackson County in the era of COVID-19? Anything that I'm forgetting that you think people need to know?
No, I think you pretty much covered it. Oh, one thing. Hold on, Amy. Just one thing, because this came up this morning with a potential client that called me. The issue of self-surrenders on criminal cases. So generally, if a person comes in and retains us and there's an active warrant out, we can call the division and we can arrange to bring them in for a self-surrender and talk about bond and all of those issues. But right now, with everything being closed, well, not closed, but limited, then that's something that I've been wrestling with all morning is how do I accomplish this with judges working remotely and in some other counties not being able to bring them in at all. So that is definitely an issue that COVID has been affecting.
Okay. I do know that if you do have the bond under 5,000, if you have a warrant, you can turn yourself into the Jackson County Sheriff's Department. Doesn't apply to anything over 5,000, but the Sheriff's Department is where you would go to turn yourself in. Stephanie, this was so great. You are so great at explaining this. I appreciate it. I know that people that see this video are seeing this video appreciate it. We will have your information to get a hold of you on in the version that's going to end up on YouTube. What is your telephone number for people right now?
816-401-2289.
Okay, and I guess I should say that this conversation could be construed as an advertisement, and the choice of a lawyer is a big decision and shouldn't be made strictly on advertisements. All right, thank you all so much. Stephanie, we appreciate you, and we'll talk to you soon.
Thank you so much. Anytime.
All right, bye everyone. Have a good day.
Bye.
All right, I'm just going to hold up because I'm going to just end this part of it. I think I can do that. I don't know if I can. If I can't, thank you, Stephanie. We will talk to you soon.
All right, no problem.
All right, okay, bye-bye.